Federal subject matter jurisdiction by way of federal question. If you're familiar with my lessons, you know I usually give you a step-by-step roadmap, and here it is. What we're exploring in the world of federal subject matter jurisdiction are the different ways to get a case into federal court. We're exploring how and under what circumstances and facts does a federal court have subject matter jurisdiction over a case. The reasons for which a party would like to litigate in federal court, those reasons are irrelevant. For the context of this course, we're focused on the how. How do we get a case heard by a federal district court? As you can see here, state courts have exclusive jurisdiction over some type of cases. Federal courts have exclusive jurisdiction over some types of cases too. And they have concurrent jurisdiction, they have shared jurisdiction over federal question in diversity cases. And a big part of this course will entail you identifying these cases right here in the middle, diversity and federal question, and explaining the legal mechanism by which they can be heard by a federal court. So the two most tested ways to get into federal court in the context of this course are federal question and diversity jurisdiction. Why? Because the federal courts have concurrent jurisdiction with state courts over these type of cases. So the analysis is not so black and white like, family law cases, for example, which are exclusive to state courts, or copyright infringement cases, which are exclusive to federal courts. The examiners want to test you on the in-between, the not-so-clear concepts. So in continuing our discussion of subject matter jurisdiction, in this lesson, we're going to focus on federal question jurisdiction. All right, so I'm going to try to keep it lean and short and sweet. And what I'm going to discuss next is very, very important for you to grasp this material properly. So here goes. There must be both constitutional power and statutory authority before federal jurisdiction can be found. For federal question jurisdiction, we have essentially two components. A constitutional component that comes from Article 3, Section 2 of the U.S. Constitution, and a statutory component that comes from 28 U.S. Code 1331. Let's see what these look like, and then I will expand upon each. The constitutional component. Article 3, Section 2. The U.S. Constitution allows federal courts to be given jurisdiction over cases arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. Stay with me because this is important. Let's look at the statutory component. 28 U.S. Code 1331 Federal Question. The district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. Now, both of these look the same at first glance, but they're not the same. Let's take a closer look. Here they are side by side. Allow me please to explain to you the difference. First, notice the constitutional language says the U.S. Constitution allows federal courts to be given jurisdiction over cases. Now, notice the statute says the district courts shall have original jurisdiction over all civil actions, thus and so. Let's talk about the constitutional component first. The Constitution creates the Supreme Court. Specifically, Article 3, Section 1 of the U.S. Constitution creates the U.S. Supreme Court. What about Article 3, Section 2? Article 3, Section 2 delineates the scope of jurisdiction of the federal judiciary as a whole. Article 3, Section 2 defines the maximum reach of the federal judicial power. It sets limits on what jurisdiction Congress can give its courts. And as I said, it basically delineates the scope of federal jurisdiction. See? The Constitution does not create the lower federal courts. The Constitution only creates the U.S. Supreme Court. Article 3 states judicial power shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. Now, notice again, the U.S. Constitution allows federal courts to be given jurisdiction by Congress over cases arising under federal law. Article 3 of the U.S. Constitution creates the Supreme Court and defines the maximum reach of the federal judicial power. And if we look at Article 3, Section 2, we see it actually establishes the scope and foundation of federal question jurisdiction in general. It denotes the range as a whole, the reach of federal jurisdiction among the federal judiciary, meaning the U.S. Supreme Court and inferior courts Congress establishes. So the Constitution gives Congress authority to create lower federal courts and determine their jurisdiction within the scope granted by Article 3, Section 2. See here? Congress creates the U.S. Federal Court of Appeals and the U.S. Federal District Courts, which are the trial courts at the federal level. Here in 28 U.S. Code 1331, we are looking at Congress actually giving jurisdiction to the federal district court, that lower court. That's where the statutory component comes from. The statutory authorization of 28 U.S. Code 1331 was generated by Congress to specify the jurisdiction of the federal district courts Congress has created. So, in 28 U.S. Code 1331, Congress created jurisdiction of the federal district courts, the federal trial courts, the federal lower courts. The U.S. Constitution creates the Supreme Court and the scope of federal jurisdiction in general. It also gives Congress the power to create the lower federal courts and determine their jurisdiction within the scope and breadth granted by the Constitution, as they do in 28 U.S. Code 1331. So the term arising under in the constitutional clause in Article 3 is much broader than arising under in the statute in 1331. This means the constitutional threshold is much broader than the statute. So how does this pertain to the federal question analysis? Well, federal question jurisdiction in the context of this course will almost always concern the scope of the congressional authorization, the narrower scope of 1331. But you will do the analysis for both the constitutional component and the statutory component. Which leads me to step 1, truly the simplest of all. Does the Constitution grant federal jurisdiction? Yes, Article 3. What does arising under mean under the constitutional definition? And the key word here is federal ingredient. If you do not find a federal ingredient anywhere in the civil action, in the claim, the defense, the counterclaim, then there cannot be federal question jurisdiction under Article 3, Section 2. If you do find a federal ingredient somewhere in the civil action, then continue and move on to step 2. But we are still in step 1, constitutional component and federal ingredient. Let's look at our first case. The federal ingredient test for the constitutional component of the analysis comes from Osborne v. Bank of the United States. In this case, the Supreme Court declared that whenever a question of the construction of the Constitution or laws of the United States formed an ingredient of the case, Congress had the power to give the lower federal courts jurisdiction over such a case. And this is the case even if the decision of the case might not actually depend upon the resolution of that federal issue, of that federal ingredient. The court has interpreted Article 3, Section 2 broadly, right? Finding that it delineates the scope of jurisdiction of all the federal courts to hear any case in which there is a federal ingredient. So what is the threshold for federal ingredient? What qualifies as a federal ingredient? Well, for the constitutional arising under, a federal defense would do. So under Osborne, who looks at the arising under from Article 3, Section 2, a federal defense is sufficient. Also for the constitutional component, a counterclaim that arises under federal law is also a federal ingredient under Osborne. Osborne looks at the arising under from Article 3, Section 2 of the Constitution. All right, that's actually it for step 1. Any constitutional ingredient will meet the broad interpretation of arising under from Article 3, Section 2. Now let's move on to step 2. This is where the meat lies. This is the material that is tested. The district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. Now remember, the district courts are the trial courts. They're the lower courts. And what is original jurisdiction? Original jurisdiction is the ability to see a case for the first time. When you go to federal court, this is the first time a court's going to see your case, you go to the lowest court, right? Usually. As opposed to appellate jurisdiction, for example. Here's a quick cheat sheet on that. And for the context of this lesson, we're always analyzing original jurisdiction of the federal district court. So now let's talk about the jurisprudence of what arising under means under 28 U.S. Code 1331, the statutory component of our analysis. How does a cause of action arise under federal law? And the two following rules must be satisfied: the well-pleaded complaint rule and the significance rule. Remember, we're going to analyze what arising under means under the statute. A sufficiently significant federal question, significance rule, presented on the face of the plaintiff's complaint, the well-pleaded complaint rule. I think this will make better sense if we begin with the well-pleaded complaint rule. This rule comes from the case of Louisville and Nashville Railroad versus Motley. Those from Kentucky, I don't know if I said Louisville right, because apparently it's not Louisville, Kentucky. Okay, I digress. In this case, the plaintiffs sued on a breach of contract claim, but they anticipated defendant to use a defense that was founded on a federal statute. The Supreme Court found that federal court did not have original federal subject matter jurisdiction under federal question because the plaintiff's cause of action, which was breach of contract, was a state law claim. Just as the defendant cannot create federal jurisdiction in the answer, the plaintiff cannot manufacture federal jurisdiction by anticipating a federal defense to her state law claims. The fact that plaintiffs anticipated a defense grounded on federal law was irrelevant. And this is true even if the defense is anticipated in the complaint and both parties admit that the defense is the only question truly at issue. So even if this federal question, this federal ingredient, is truly what's at issue, it does not meet the well-pleaded complaint rule. It has to be a cause of action in the plaintiff's complaint, not a defense, not even a defense, an anticipated defense by the defendant. Michael from Studicata has a great video explaining this case in more depth. If you're interested, we do not need the case explained in depth for the purposes of this lesson or for the bar exam. Okay, so the well-pleaded complaint rule. Jurisdiction under 1331 federal question must be determined from plaintiff's complaint. And this is very different than what we discussed just a few moments back when we were discussing Osborne's federal ingredient test, right? Remember that the scope of 1331 pertains to the original jurisdiction of the federal district court only, and is much narrower than the scope of Article 3, Section 2 of the Constitution granting federal jurisdiction to the federal judiciary as a whole. The federal question upon which the lawsuit is based must appear as an essential part of the well-pleaded complaint. A complaint does not create federal jurisdiction if it alleges federal issues only in anticipation of some defense. And note that, for the purposes of asserting federal jurisdiction under federal question, the content of a defendant's answer, defense, or counterclaim is not relevant. Let's talk now about the significance rule, sufficiently significant federal question. The appearance of a federal question in the plaintiff's well-pleaded complaint does not, in and of itself, automatically grant a federal court federal question jurisdiction over a case. The federal question must be sufficiently significant. And what does sufficiently significant mean, or does it mean? Well, let's explore some of the most notable cases regarding this. In order for a federal claim to be considered sufficiently significant to fall within the jurisdiction of a federal district court, the lower court, it must meet either one of two tests. The creation test, which is the default, and it's the one that will most likely apply. or the Grable test, which is applied when a federal question is embedded in the state law claim. Let's begin with the creation test. This test comes from the case of American Well Works versus Lane. In this case, Justice Oliver Wendell Holmes suggested a test to determine when Motley's well-pleaded complaint rule is met. The creation test. A lawsuit arises under the law that creates the cause of action. If that law is a federal law, then it meets Motley's well-pleaded complaint rule. This test would find jurisdiction under 28 U.S. Code 1331 if the source of the plaintiff's enforceable right against defendant is federal law. And this is a default test, and the most likely to apply to the facts. What federal law does the cause of action have to arise under? Well, federal common law, federal constitutional law, federal statutory law, treaty law, federal administrative regulations. However, it is important to note that just because a cause of action is based on a federal statute or law, it does not mean it meets the creation test. Let's look at Merrill Dow Pharmaceuticals, Inc. versus Thompson. The Federal Food, Drug, and Cosmetics Act lays out standards that pharmaceutical companies must follow. Merrill Dow did not comply with these standards, and as a result, plaintiff's child was injured by its products. The plaintiffs are saying, hey, look, Merrill Dow Pharmaceutical did not follow these standards under the Federal Food, Drug, and Cosmetics Act. And this is how plaintiffs try using this non-compliance by Merrill Dow as evidence to show there was negligence committed by Merrill Dow. So notice, the cause of action itself is negligence, which is a tort, which generally is a state law claim. And this state law claim, the plaintiffs argue, has a federal issue embedded within it. And the federal issue is whether Merrill Dow did not comply with this standards statute. Nonetheless, the court found here that the federal issue embedded in the state law tort claim was insufficiently substantial to confer federal question jurisdiction, because when Congress enacted the Federal Food, Drug, and Cosmetics Act, it did not create a private right of action, a right for a private citizen to sue for a violation of these federal standards. The Federal Food, Drug, and Cosmetics Act is comprised of just standards for pharmaceutical companies to follow. There was no actual cause of action created for a private party to sue in federal court for violations of this standard. So the court in Merrill Dow concluded that if Congress did not create a right of action for a private party to sue under the statute when there's a violation, then federal question jurisdiction is not present. And what is a federal right of action? A federal right of action is a legal device that allows plaintiffs to enforce a federal statutory or constitutional right. A federal right of action authorizes plaintiffs to pursue remedies when there is a violation of a federal law. And a right is a claim to receive a certain treatment, and the right of action is a tool for enforcing that claim in court. Here is a very loose and basic example, a kindergarten example. No discrimination against a person for X, Y, and Z. This here is the right of action. If discrimination against person for X, Y, and Z, person can sue for relief. So in the context of federal courts, a private right of action can stem from a federal statute or the U.S. Constitution. Please note that the Supreme Court has stated that a right of action, if not explicitly created by Congress, can exist within a statute's right-creating language. And what this means is that the right of action does not have to be express. It can be implied. This does happen, and we will see it soon in another case. However, I want to err in the side of caution and mention that the court has become increasingly reluctant to imply private rights of action into federal statutes that do not expressly provide for them. So, an implied right of action is an exception. It's not the rule. The position of the Supreme Court today is that an implied right of action is a rarity. Let's talk about implied federal right of action super quick. Implied federal right of action is a judicially inferred right to relief from injuries caused by another's violation of a federal statute. It is not essential that a federal statute expressly provide for a civil cause of action for the violation of the statute. In Court v. Ashe, Justice Brennan laid out 4 factors for determining when a cause or a right of action should be implied from a statute. 1. Is the plaintiff within the class for whose benefit the statute was enacted? For example, does the statute create a federal right for plaintiff? 2. Is there any indication of legislative intent, explicit or implicit, either to create or deny a cause of action? 3. Is it consistent with the underlying purposes of legislative scheme to imply such a remedy for the plaintiff? And 4. Is the cause of action one traditionally relegated to state law in an area specifically of concern to the states, so that it could be inappropriate to infer a cause of action based solely on federal law? However, again, note that the court has become increasingly reluctant to imply private rights of action into federal statutes that do not expressly provide for them. But I want you to distinguish between these two concepts. In Bell v. Hood, federal question jurisdiction was held to exist in any action involving an alleged violation of the Fourth and Fifth Amendments. These are constitutional clauses. These are not congressional statutes. So yes to federal question for any violation of the Fourth and Fifth Amendments. Distinguish this from Court v. Ashe, which says that not all federal provisions creating duties are held to create an implied private right of action. Just because it's creating a duty for an entity does not mean that it's creating a right for a plaintiff. And like I said a minute ago, the general position held by the Supreme Court today is that Congress creates federal causes of action, not the judiciary. If the text of a federal statute does not provide a cause of action, there ordinarily is no private right of action. So, an implied right of action will be a rarity. For the most part, if a federal statute does not explicitly create a private right of action, a private cause of action, then it's not meant to be a statute under which a private citizen can bring a lawsuit. Back to Merrill Dow. So under the creation test, the court said that a lawsuit under the Federal Food, Drug, and Cosmetics Act is insufficiently substantial because it's merely a standard set forth by the FDA. Congress did not create a right of action. Congress did not mean for private citizens to be able to sue under that statute. It's insufficiently substantial to confer federal question jurisdiction. It was merely a set of standards for pharmaceutical companies to follow. Moving on. Just a reminder of where we are in the analysis, we're discussing what arise under means under 1331, original jurisdiction of the federal district courts. And the following rules must be satisfied. First, the well-pleaded complaint rule and the significance rule. We're talking about the significance rule now. We looked at the creation test, which is the default test, the classic federal question case, if you will. If the creation test does not apply, then you check if your facts fall under the Grable test, which is what we will cover next. Now let's look at the Grable test. Before I talk about the Grable and Sons case, first let me talk to you about Smith v. Kansas City Title and Trust, which involved a state law claim revolving around a substantial federal issue. The state law claim in Smith failed to satisfy the creation test, but it nonetheless was considered to arise under federal law. You need not know the entire story, but the difference in this case was that the plaintiffs here could not prove their state law claim without establishing a substantial issue of federal law. The federal issue was embedded in the state law claim and necessary to its resolution. So this kind of set the groundwork for Grable and Sons. Much later, the Supreme Court, in the 1983 case of Franchise Tax Board v. Laborers Vocation Trust, suggested that the exception in Smith regarding the embedded federal claim is a viable basis for finding federal jurisdiction under 1331. The rule that ultimately came out of Grable and Sons is applied when a federal question is embedded in a state law claim. Under Grable, a federal court has federal question jurisdiction if the state law claim, 1, is necessarily raised. Plaintiff's right to relief must necessarily depend upon a federal law. Two, it is actually disputed. The federal issue is actually disputed. It's actually contested in court. If the federal issue is settled, for example, or the answer to the federal question is clear, its presence in a state law cause of action should not trigger federal jurisdiction, right? It's not disputed any longer. Three, substantial, meaning the federal issue was important and the federal court had a strong interest in addressing the issue. And lastly, capable of resolution in federal court without disrupting the federal-state balance. This means that exercising jurisdiction will not interfere with the congressional balancing of federal and state judicial responsibilities. This disruptiveness prong, this last prong, is a possible veto, grounded in the principle that Congress controls federal jurisdiction. Even when a federal issue is necessary, actually disputed, and substantial, jurisdiction is still improper if exercising it would be disruptive. Which brings me to my next point. Let's do a quick comparison between Merrill-Dow and Grable. Indulge me. It's important that you grasp this material and that you see the difference between the two cases. In Merrill-Dow, the plaintiffs incorporated the Drug Act standard into their negligence claim against the pharmaceutical company. And they alleged that because the pharmaceutical company did not meet the standards of this federally created Drug and Cosmetics Act, their child was injured. Now, negligence is a state claim to be heard by a state court, but plaintiffs alleged federal question jurisdiction on the basis that their negligence claim particularly hinged on the answer to the question of whether the pharmaceutical company did not meet the standards imposed by the Federal Drug and Cosmetics Act. So they claimed a federal question was inevitably embedded in their state law negligence claim, and therefore felt that federal jurisdiction was present and they could litigate the case in federal court. However, the Drug Act did not create a private right of action explicitly. It did not create the right to sue by a private party. It really was not a statute meant to create private rights. So the plaintiff's state law tort claim needs to remain in state court, even though we've got this federal ingredient embedded where there's this potential violation of some federal standard in terms of manufacturing pharmaceuticals, right? The court stated that because there's no cause of action, no right of action, this embedded federal issue is insufficiently substantial to confer federal question jurisdiction, at least under the creation test. Now let's look at Grable on the right. This case happened 20 years after Merrill-Dow. In Grable, the plaintiff, Grable, had his land seized by the IRS to pay off taxes owed. After being notified by certified mail, the land was given to Darrow. Grable then filed a state law quiet title action against Darrow. Darrow, of course, wants to move this action to federal court. Darrow argued federal question jurisdiction existed because the state law in the cause of action, quiet title action, depended on the interpretation of federal tax law. So here, 20 years later, in Grable, the court is basically saying, well, just because a federal cause of action is not created explicitly when Congress enacts the law, that's definitely evidence no cause of action exists for federal jurisdiction under this federal issue, right? Just like Merrill-Dow. The lack of an express cause of action is relevant on how significant the federal question is. Yes, true, but it's not dispositive. Instead, we're going to rely on these four elements: whether the federal issue is necessarily raised, actually disputed, substantial, and capable of resolution in federal court without disrupting the federal-state bounds approved by Congress. In Grable, the Supreme Court says, look, these four elements are met, and therefore the federal issue embedded in the state law claim does indeed confer federal question jurisdiction to the federal district court. But wait, my students always protest this portion of my lesson and ask me to please give them a concrete reason why these cases were decided differently. Both cases did not have an explicit right of action, right? Why did Grable get a yes, there is federal question, and Merrill-Dow did not? I say it's the fourth element. All right, here goes my explanation. Hear me out. Both cases here meet elements 1 through 3. But let's do a comparison of the fourth element. In Merrill Dow, the plaintiffs incorporated the standards within the Federal Drug Act into their negligence per se claim. The Drug Act did not create a private right of action for private parties to sue an entity when there was a violation of these standards. A right of action was necessary in that case specifically because allowing garden variety tort claims like negligence into federal court merely because it incorporates federal law would have heralded a potentially enormous shift of cases traditionally belonging in state courts into the federal courts. When allowing a type of embedded issue into federal court would attract a horde of original filings and removal cases in federal courts, which are supposed to be courts of limited jurisdiction, federal courts need the congressional right of action even if the issue is substantial enough to warrant federal jurisdiction. See why it's the fourth element? Even though at the time of Merrill Dow in 1986, the four Grable elements did not exist yet, had these elements existed, the facts under Merrill would have failed this fourth Grable element. It would have absolutely been quite disruptive of the federal-state balance. Negligence is such an incredibly common cause of action, allowing a federal minimum standards act, like the Drug and Cosmetics Act, to carry with it rights to a private citizen and a concealed implication of a federal right of action by private parties in the absence of an express right of action in the statute itself would open the floodgates for federal jurisdiction for any federal minimum standards act out there, which are really meant for the government to regulate, certify, fine corporate entities, right? Not for private citizens to be suing under every violation. If you add to that fact that the cause of action itself is a state law claim, a tort, negligence, which is probably the most common tort, it would absolutely, totally disrupt the balance between federal and state judicial responsibilities. By contrast, in Grable, federal question jurisdiction was proper despite the absence of a federal right of action because a state-wide title action that involves contested issues of federal tax law is not garden variety. It's not common, not like negligence. And who better to decide what a federal tax law means or implicates than a federal court? This won't open the floodgates. Thereby, as the court noted, exercising jurisdiction over actions like Grable's would not materially affect or threaten to affect the normal currents of litigation. So it is this fourth element right here where the difference between these two cases lies and what explains this seemingly inconsistent outcome for each case. Okay, done with the case law. I made this little guide using a traffic light for a student that was struggling with these concepts, and my students have found it really helpful so far, so I hope you do also. Is there federal question jurisdiction under 1331? Again, we're looking at the statute 28 U.S. Code 1331, and we're analyzing jurisdiction of the federal district court, right? The lower trial court at the federal level. If the federal issue does not form part of plaintiff's complaint, for the purposes of asserting federal subject matter jurisdiction under federal question, the content of a defendant's answer, defense, or counterclaim is not relevant, not for 1331. So no federal question if the federal issue does not form part of the plaintiff's complaint. Even if it's a state law claim with a federal issue embedded, it needs to be in the complaint. It needs to be part of the plaintiff's cause of action. Next, maybe federal question. So maybe federal question if the federal issue is embedded in the state law claim and it's necessary to its resolution. That's when you do the Grable analysis. Yes, federal question if there's a federal cause of action. So a cause of action arising under federal law, a lawsuit arises under the law that creates the cause of action. This is a creation test. Okay, to recap, how does a cause of action arise under federal law? The two following rules must be satisfied: well-pleaded complaint rule and significance rule. So, a sufficiently significant federal question must be presented on the face of the plaintiff's complaint. Sufficiently significant entails the federal question falling under the creation test or the Grable test. And the well-pleaded complaint rule means that the federal question upon which the lawsuit is based must appear as an essential part of a well-pleaded complaint. All right, guys, moving on. I'm going to very briefly touch upon a highly tested topic. I won't go into it in this lecture. It will be covered in depth in another lecture, but I will briefly discuss the part that pertains to federal question jurisdiction. What happens if a plaintiff has a federal claim that meets the requirements of federal jurisdiction, but also has a state claim, a claim based on state law? Would she have to file the federal claim in federal court and then the state claim in state court? Not necessarily. She could likely file both claims in state court, right? Since state courts are courts of general jurisdiction. Or if the claims are sufficiently related to one another, she could file both in federal court. If the claims derive from a common nucleus of operative fact, then the federal court can exercise supplemental jurisdiction over the related state claim. Supplemental jurisdiction allows for federal courts to assert jurisdiction over state law claims with no independent jurisdictional basis and that have a sufficient nexus to the federal claim being brought before the court. For supplemental jurisdiction to apply, the claim founded on state law must arise from a common nucleus of operative fact as the main claim that is properly in federal court, the one that meets federal subject matter jurisdiction requirements. So if the claims are sufficiently related, they can both be filed in federal court. For my visual students, this is what would be happening. The related state claims would be practically piggybacking on top of the federal claim for which the federal court does have subject matter jurisdiction. And supplemental jurisdiction can also apply to counterclaims and cross-claims. If a counterclaim grounded on state law derives from a common nucleus of operative fact as the federal claim properly before federal court, then the court might be able to exercise supplemental jurisdiction over it. Same for cross-claims between co-defendants or co-plaintiffs. Supplemental jurisdiction allows a federal court to take jurisdiction of a state law claim against one party if it were related closely enough to a federal claim against another party, even though there was no independent jurisdictional basis for the state claim. So plaintiff has a federal claim against defendant 1 and a state claim against defendant 2. The entire action here can be brought in federal court if the two claims derive from a common nucleus of operative fact. Supplemental jurisdiction can also be asserted when more than one plaintiff asserts claims against one defendant. Here, if the state claim is related closely enough to the first plaintiff's federal claim against the defendant, the second plaintiff may assert her state claim lacking independent federal subject matter jurisdiction against that defendant. So plaintiff 1 has a federal claim against defendant and plaintiff 2 has a state claim against defendant. If these two claims are sufficiently related, if they derive from a common nucleus of operative fact, the federal court has discretion to see the entire case, even these state law claims that independently would not belong in federal court. Please watch my full lesson on supplemental jurisdiction. It's very important that you do. I just gave you a very, very quick and superficial summary of supplemental jurisdiction when it comes to federal question only. Okay, let's do a quick recap. Two of the most covered and tested ways of getting into federal court are federal question and diversity jurisdiction. The parties that meet diversity or federal question have a constitutional right to have their case heard by a federal court. For federal question jurisdiction, we have essentially two components: a constitutional component that comes from Article 3, Section 2 of the U.S. Constitution, and a statutory component that comes from 28 U.S. Code 1331. The language of the two is very similar in language, but their scope and reach are very different. The constitutional authority is much broader than the authority conveyed by the statute. The constitutional authority pertains to the entire federal judiciary, whereas 1331 only pertains to the original jurisdiction of federal district courts. So for the context of federal question, we're looking at the scope of this statute of 1331 in order to bring a case into federal district court, which is the trial court, the lowest court at the federal level. Arising under federal law is much more narrow under the statute. What does it mean when a case arises out of federal law? There must be a sufficiently significant federal question presented on the face of the plaintiff's complaint. For the significance rule, there are two alternative metrics: the creation test, which is a default, and the Grable test, applied when a federal question is embedded in a state law claim. And for the well-pleaded complaint rule, the federal question upon which the lawsuit is based must appear as an essential part of a well-pleaded complaint. Here is a little cheat sheet that might prove helpful. And here is your step-by-step analysis. And here is a list of the exclusive jurisdiction of federal courts. So these type of cases can only come before a federal court, can only be filed in federal court. All right, guys, we have reached the end of our lecture. I really hope this video was valuable to you, and if this is how you're feeling after this lesson, email me at questions@jdsimplified.com.